Hello friends, welcome to my YouTube channel, T Zaman's Polity and Governance. So today we are going to take up another very important topic, and that is quite relating to current affairs, and most of you, I'm sure, must be acquainted with, must be aware of that topic. So here it is. Do you know that an under trial prisoner can contest elections but cannot exercise his right to vote during elections? So who is an under trial prisoner? Under trial prisoner, a prisoner who is not yet convicted, okay, against whom the case is going on, okay, so he is an under trial prisoner. So now the question is whether an under trial prisoner can contest elections, whether an under trial prisoner can exercise his right to vote during elections. So these are the two questions. Now the answer is that an under trial prisoner can contest elections but cannot exercise his right to vote during elections. So that's the topic for the day. So keep watching, please. Now, before we take up the discussion, could you please recognize this figure? He is the main figure. I'm sure most of you must be recognizing him by his face. You must have come across this figure in newspapers and also must have heard in the news. He is Amritpal Singh. He is behind bar. He is jailed and he is the leader of the pro-Khalistan outfit, right, in Punjab. And he has been put behind bars on allegations that he was indulging in anti-national activities, terrorist activities. So there are cases like NSA, National Security Act, against him. And there are many other such cases against him. So he is behind bars. He is an under trial prisoner as of now. He is not yet convicted. He is an under trial prisoner. You can see here Amritpal Singh, the jailed head of pro-Khalistan outfit Waris Punjab De. So you should remember the name of the outfit as well. He contested Lok Sabha elections from one of the constituencies in Punjab in the general elections that was just held. From Khajur Sahib Lok Sabha constituency, and he also won the seat. Right? He is an under trial prisoner lodged in Dibrugarh jail under NSA and other alleged offenses. Okay, so he is lodged in Assam's Dibrugarh jail. So in this video, we are going to discuss these two questions. These are interrelated questions, right? So the first question is, can an under trial prisoner, that is an accused person in custody, so he is not yet convicted, the charges against him is not yet proven in the court of law, so he is not yet convicted. He is just a prisoner because he is in the prison because the cases against him are going on. So the question is, can an under trial prisoner exercise his right to vote or contest elections? What the law says about it. So we have to understand the legal position, right? Exactly. And related with this, what is the legal status of the right to vote and right to contest elections? Right to vote can also be called right to franchise. Right to contest elections can also be called right to be elected, right? So what is the legal status of these two rights, right to vote and right to contest elections, right? So first thing first, we are going to take up the first question, that can an under trial prisoner exercise his right to vote or contest elections? So you have got the answer. Yes, an under trial prisoner can contest elections, but he cannot exercise his right to vote. So that's the answer. But we are going to discuss the exact legal position, right? While an under trial prisoner can contest elections, he cannot exercise his right to vote as long as he is behind bars. Okay? So by implication, even if he is an under trial person, but he is out on bail, then he can exercise his right to vote. However, an under trial prisoner who is out on bail can exercise his right to vote. For instance, this year, when the elections for Delhi Delhi Lok Sabha constituencies were going on 25th of May, Arvind Kejriwal, who was behind bars on some accusations, right, in Tihar jail, just prior to that polling day, he had been given bail, right, to make conversing, to involve himself in the poll preparation, etc. And then he could also exercise his vote because he was out on bail. Had he been behind bars, he could not have been able to exercise his right to vote, just like any other under trial prisoners. Okay? It is only when a person is convicted by a court of law that he or she loses the right to contest elections. Right? So if Amritpal Singh is convicted someday, for instance, then he would be losing his right to contest elections. Right? In fact, if a person who is also a member of parliament and if he's convicted in the meantime by a court of law, then he becomes disqualified to continue in his position as an MP, as a member of legislature, as happened in the case of Rahul Gandhi, that he was a continuing MP, but since he was convicted in a case by a court of law, and therefore he was disqualified from being member of the house. Right? Similarly, if a person who is not an MP, MLA, but he is convicted by a court of law, he will also be disqualified from contesting elections. I hope you understand the difference between right to contest elections and right to vote. So for a prisoner who is an under trial and he is also behind bars, he has no right to vote, right? He cannot exercise his right to vote, right? And if a prisoner who is an under trial, okay, then he can contest elections, right? So that's the legal position. Now, what is the legal status of the right to vote and the right to contest elections? That is the right to be elected, okay? The right to vote and the right to be elected are both statutory rights. That is, they are not fundamental rights. And now you should be knowing that what is the difference between a statutory right and a fundamental right. I'm sure many of you must be knowing, but for your benefit, I must say that a fundamental right which is mentioned in the Constitution in Part 3 is guaranteed by the Constitution against its violation. Okay? A fundamental right cannot be violated by an ordinary law of the land. Ordinary law means a law that has been simply passed by a legislature, that is parliament or state assembly. But if a right is not a fundamental right, if a right is a statutory right, that is a right that has been granted by a law passed by the parliament, that is a simple statutory right. Simple statutory rights have no constitutional guarantee. Means they could be taken away, the scope of such rights could be restricted, such rights could also be repealed, okay, by another ordinary law of parliament. Right? So that's the difference between a fundamental right and a simple statutory right. I hope you understand. Now, what we are saying is that both these rights, right to contest elections as well as right to vote, these are simple statutory rights, not fundamental rights. Even though the two are statutory rights, they do not enjoy the same status. Means the law has treated the two rights differently in some respects. So let's understand that. For instance, while the right to vote or right to elect is restricted for under trial prisoners, the right to be elected is available to them. In other words, while they cannot vote, they can contest elections. That way, the law has kept the right to contest elections at a higher pedestal, vis-a-vis the right to vote, right? Right to be elected or contest elections is restricted only in case of convicted prisoners, as we already discussed earlier, that only in case a person is convicted by a court of law, then only he will lose his right to contest elections, but not otherwise. Okay? Now, what has been the Supreme Court's stand on this? A 5-judge constitution bench in 2006, in the case, so what is the name of the case? Kuldeep Nayyar versus Union of India, 2006. So you should remember this important case in which the Supreme Court held that the two rights, that is right to vote as well as right to contest elections, the two rights are statutory rights. So it is well established now by the Supreme Court that these rights are not fundamental rights. So there, questions were raised initially that right to vote springs from Article 19(1)(a), that is freedom of speech and expression, and therefore, and also Article 326, which guarantees every Indian citizen, universal adult franchise. So, making a reference of Article 19(1)(a), people believed that right to vote, which is also a form of expression, is a fundamental right. But the Supreme Court has established already in this particular case, landmark case, that these rights are pure and simple a statutory right. Okay? So, right to vote as well as right to be elected are statutory rights, not fundamental rights. By implication, both rights, that is right to vote and right to contest, being ordinary rights, can be restricted by ordinary laws of the land, ordinary laws made by the legislature. Okay? And unlike in case of fundamental rights, the principle of reasonable restrictions will not apply. So, those who have studied fundamental rights, they would know that fundamental rights which are guaranteed under Part 3 of the Indian Constitution can only be restricted up to a reasonable level, and only on grounds which are specified in the Constitution, right? So fundamental rights cannot be restricted by an ordinary rights unless they restrict the rights on the grounds mentioned, specified in the Constitution, and also such restrictions must be within the reasonable limit. But these principles do not apply in case of a statutory right. So a statutory right can not only be restricted, amended, but can also be taken away, repealed from the statute book by another ordinary law. Okay? So that's the implication. So unlike in case of fundamental rights, the principle of reasonable restriction does not apply. Moreover, unlike in case of fundamental rights, the grounds for reasonable restrictions are not mentioned to restrict the scope of such rights. I hope it's clear to you now. Moving next, what does the law say about restriction on the right to vote? Now, the ordinary law, that is a statute, that is RPA. Representation of People's Act is a very basic fundamental law governing election system in India, right? There is another law, that is Representation of People's Act 1950, but the two laws have different purposes, okay? Different jurisdiction. So we are talking about RPA, that is Representation of People's Act 1951. So one of the sections of this law, that is section 62, that provides a series of restrictions on the right to vote, including its subclause 5. So within this section, there are many clauses, many subsections. So subsection 5 of this law says, you can see here, no person shall vote at any election if he is confined in a prison, whether under a sentence of imprisonment or transportation or otherwise, or is in the lawful custody of the police. So if a person who is convicted by a court of law and is behind bars, okay, another person who is not yet convicted, but he is in lawful custody of the police or judicial custody, that is in jail. In all such cases, such prisoners, such persons, those persons who are behind bars, they will not have the right to vote. So that is subclause 5 of section 62 that very clearly mentions, okay, that restriction. This provision effectively bars every individual who had criminal charges framed against them from casting their vote unless they have been released on bail or have been acquitted by the court of law. Okay, so however, then exception has been made for those who are under trials, who are behind bars, but they are behind bars under laws which are in the nature of preventive detention laws. So, preventive detention laws are to be distinguished from punitive detention laws. So, persons who are put behind bars under preventive detention laws, the UAPA is also a preventive detention law, but not the entire UAPA, only some provisions of UAPA. You must have heard of UAPA, very stringent law, Unlawful Activities Prevention Act, 1967. So, UAPA, that's preventive detention laws. National Security Act, NSA, you must have heard of it, RASUKA, Rashtriya Suraksha Kanun. Okay, earlier we had TADA and many such laws. Okay, so and every state government has its own set of preventive detention laws. In Maharashtra, they have MACOCA, Maharashtra Control of Organized Crimes Act, MACOCA, a very stringent, notorious law. Okay, so under such laws, it is very difficult to get bail, right? So, anyway, so if a person has been convicted under preventive detention laws, then preventive detention sections of many laws, it may be possible that the entire law is not preventive detention nature, but some of the provisions under whom a person has been put behind bars, such provisions are of preventive detention nature. Then in that case, that person shall have the right to vote. Okay, if there is a polling day and he is behind preventive detention, then he shall be given the right to exercise his vote, right? So that's the exception. What has been the Supreme Court's views on such matters, right? So a petition was filed before the Supreme Court saying that there is a discrimination between people and therefore there is a violation of right to equality. What is the discrimination about? That while a person who is on bail, who is accused but on bail, who is out on bail, he can exercise his right to vote, but a person who is also an accused, not yet convicted, against whom accusations are not yet proven in the court of law, and if he is not out on bail, he cannot exercise his right to vote, right? So there is, the law discriminates between people, between persons who are similarly placed. Means accusations are against both persons A and B. A is out on bail, whereas B has not been given any bail yet, even though the charges are not proven in both cases. Okay, so while A can go and vote, B cannot. So this is ostensibly, prima facie, this seemed to be what? Discriminatory provision of RPA. And therefore, PIL, public interest litigations, were filed in the Supreme Court, and such petitions challenged the validity of Section 62(5), okay, which had denied right to vote to under trial prisoners while allowing the same to those who were out on bail in similar cases. The petition argued that the provision of the law was discriminatory and violative of the fundamental right to equality that is guaranteed under Article 14 of the Indian Constitution. The Supreme Court, however, in the Anukul Chandra Pradhan Advocate Supreme Court versus Union of India, this is also another important Supreme Court judgment which was delivered in 1997. The Supreme Court rejected the argument, okay, argument put against section 62(5) and said that the law is valid, not unconstitutional. So what arguments did the Supreme Court put forth? 4 arguments. These are the 4 arguments. You can see here that the right to vote was a statutory right and could be subject to statutory limitations, right? So since this is not a fundamental right, so the implication of Article 14, the scope of Article 14 will not apply in this case. Had it been fundamental right, then the scope of Article 14 guaranteeing right to equality could have been applied here. Okay, so that's very important argument on the part of the Supreme Court while rejecting the petition. It held that there was a resource crunch as infrastructure would have to be provided and police would have to be deployed. If under trial prisoners, every under trial prisoners, if they are given the right to vote, then on the polling day, every prisoner of the city, okay, who are registered voters in some booth, they will have to be given opportunity to cast their vote by physically moving out of the jail premises and going up to their respective booth. So that will require a lot of resources, manpower, logistics, security, paraphernalia, etc. And therefore, the court argued that this is not that important thing, since this is only a statutory right, and for that purpose, we cannot, go to this extent. A person in prison, because of their conduct, cannot claim equal freedom of movement, speech, and expression, right? Now, not every under trial is gentleman, or he is behind bars on false accusations, right? There are many hardened criminals against whom the conviction has not yet taken place. They are also under trial. Their status is also one of under trial, but they cannot be treated so, in such a clumsy manner. And therefore, the court also said that such persons against whom there are criminal charges, they do not deserve to be treated that way. So, now the last argument, restrictions on prisoners' right to vote are reasonable as it is connected to keeping persons with criminal background away from the election scene. Now see, conducting free and fair elections is also declared as a basic feature of the Constitution. Now, the fact that prisoners in the city, they are given a chance to go out and vote, that could pose a security threat on ordinary people, the voters standing in the queue, and that can also threaten the security environment all around. And therefore, it is not good, it's not consistent with the demand of a free and fair election. And therefore, such petitions were considered not bona fide. The court rejected the petitions that challenged Section 62, Clause 5 of the RPA 1951. This decision has been relied upon by both the Supreme Court in 2023. So once again, the case, such petitions were filed. The court had the same view and rejected such petitions in 2023 as well. Then Delhi High Court also in 2020, in recent past, to dismiss pleas seeking voting rights for prisoners. So Supreme Court, time and again, had followed the same stand, and Delhi High Court has also rejected such petitions on similar grounds. So the core point here is that right to vote is not a fundamental right. It's simply a statutory right. And therefore, right to vote for under trial prisoners cannot be given that much of importance, right? More important here is to allow free and fair elections throughout the country. And therefore, such rights of the individuals could be given a backseat. Now, what does the law say about restriction on the right to contest elections? So we already discussed about right to vote. Now it is right to contest elections. So what the law says? The law is more liberal in case of right to contest elections, as it allows an under trial prisoner to contest elections. It only forbids a convicted prisoner from contesting elections, right? However, Section 8 of the RPA 1951, that is titled Disqualification on Conviction for Certain Offences. So, in Section 8 of RPA, there is a list of such specified laws which, if criminal laws, which, if violated, in that case, and the person has been convicted, in that case, the person in question shall lose the right to contest elections. He or she will immediately become disqualified from contesting elections. So what you have to remember is Section 8, and there are many subsections within 8, right? Within Section 8. And each subsection gives you a list and some grounds on which, if a person is convicted, then he or she can be disqualified from contesting elections. It happened, as in Rahul Gandhi's case, as in Azam Khan in UP, his son Abdullah Azam, and many such persons in recent past, who some of those were, continuing existing legislators. So they were immediately disqualified. They lost their membership of the House. And not only that, they lost their membership of the House, but they also were disqualified from contesting elections for another 6 years, okay, after the completion of the sentence. Okay. However, in Rahul Gandhi's case, initially he was disqualified because the Surat court convicted him for and also sentenced him for 2 years. So Section 8 says that if a person who is convicted on certain specified cases, and if he is sentenced also for at least 2 years, then he or she will be disqualified from the membership. So Rahul Gandhi immediately became disqualified. However, in the meantime, he made an appeal before the superior courts. So finally, he got his conviction stayed from the Supreme Court. Once his conviction was stayed, then he got back his Lok Sabha seat. And not only that, he got back his Lok Sabha seat in the last Lok Sabha, but he could also contest elections. Clear? So his case was a little different, and there are many people who become disqualified and their convictions are not stayed by the superior court, and they are not only disqualified from membership of the House, but they are also barred under the law from contesting elections for a period of sentence plus 6 years. So if a person is convicted of any of the offenses which are specified in the section, that is Section 8, he or she will be disqualified from contesting elections to Parliament or state legislatures from the date of conviction onwards and face further a 6-year disqualification from contesting in elections beginning from the date of the release. However, the law also provides for exception to disqualification even in case of conviction. Now, exceptions normally are always there. So in this case, the exceptions have been given in 2 instances. For instance, number 1, I told you that if the superior court stays back the conviction of the person, then he or she shall, this section will not apply. Okay, he or she will not be disqualified from contesting elections. Okay, so this is one. That is, where a disqualified MP or MLA can still contest is when there is conviction, their conviction is stayed on an appeal by higher court. Another exception is this, that Election Commission of India under Section 11 of RPA has been given the power to reduce the quantum of disqualification period, right? Okay, so what is mentioned here, the ECI, that is Election Commission of India, is empowered under Section 11 of the RPA to remove or reduce the period of disqualification. It happened several times. In example, in 2019, the Election Commission of India used this power to reduce the period of disqualification faced by Sikkim Chief Minister, then Sikkim Chief Minister Prem Singh Tamang, who was disqualified, okay, who was convicted and because of conviction disqualified from the House and also from further contesting elections. But the quantum of disqualification period was reduced by the Election Commission of India when he approached the Election Commission of India for this purpose. Okay, so there are two situations. Either the Election Commission of India itself takes such kind of view and exercises its power under under Section 11 of RPA, or the person who is disqualified, he appeals against the conviction in a superior court. Okay, and the superior court takes a lenient view and stays the conviction of the person. So in these two cases, the person can not only contest elections, also can also become member of legislature. Why such paradoxical provisions? So these provisions are, they sound to be paradoxical, that while a person who is behind bars, under trial person, he can exercise his right to contest elections, but he cannot exercise his right to vote. So these seem to be paradoxical in nature, right? The reason is, while for contesting election, one does not necessarily need to come out of jail, but for exercising his vote, he has to be physically out of jail or out of custody. And that will pose security threat, etc. That will also cost heavily to the state exchequer. That will also engage unnecessarily the administrative paraphernalia who are already busy in holding elections. Allowing under trial prisoners, many of whom may be hardened criminals, may not only pose security threats to other voters, but would also undermine the process of free and fair elections by vitiating the environment. I hope you understood this. Okay, that the law does not treat the two statutory rights on the same footing, while under trial prisoners could be allowed to contest elections, they cannot be allowed to vote. So that is the justification, that is the rationale why they cannot be allowed to go out and vote, while they can be allowed to contest elections. Because for contesting elections, one need not necessarily go out of jail. One can contest elections without physically involving himself or herself in the election process. Okay, as happened in the case of Amritpal Singh. So Amritpal Singh remained behind bars and fought elections. He also won the election. Now he is a member of parliament. Sometime he will be given bail, by the court, maybe to take an oath of office as a member of parliament, right? So before we wind up for the day, please look at this question. Please test yourself. Which of the following statements given below is or are correct? An under trial prisoner can vote but cannot contest elections. Is this correct? No. An under trial prisoner can contest elections but cannot exercise his right to vote. Correct? I'm sure you understand this. Yes, this is correct. And under trial prisoners can neither vote nor contest elections. Okay? Not correct. An under trial person who is out on bail can vote in elections. Yes, who is out on bail can vote in elections. Correct? So which are the correct 2 and 4? So this should be the right answer. Next, which section of RPA 1951 bars under trial prisoners from exercising their voting rights? Section 62, and more precisely section 62 subsection 5. Okay, which section of the RPA 1951 bars a convicted person from contesting elections? It's section 8. Okay, so remember this. So guys, I'm sure these are technical things, but then you must have tried your best to understand and appreciate and also grasp what has been discussed. So please, I would advise you to revisit this entire lecture, okay, rewind this entire lecture and try to grasp what has been discussed. So thank you, take care.